what is it that we want to know? And what is it that we know already about the media law? Before I walk you through the general overview of the entire course that is taught as a core unit for journalists in practice and those who are seeking a university degree to join the practice, I would like to begin by admitting that we live in a world that is highly opinionated and mediocre when it comes to the quality of information that we are subjected to. That doesn't mean at all that there are no individuals that consume quality products from the media and those who read and go thorough in every information they receive. However, still the vast majority rely on the social media platform to acquire and receive and share information. This is the reality of the world today, which of course any reasonable and right-thinking person can not deny. Media law can be understood only by understanding the following concepts in the law. Concept number one, which I believe is very defining, is known as the freedom of expression. That includes the freedom of opinion, the freedom of speech, but also the freedom of the press. Number two is the concept of defamation, defamatory reporting, or defamatory way of speaking can be seen under the two concepts. Number one, libel, that is through publication, and publication can be in print media. Publication can be in form of a textbook that is procedurally published, or journal article, or newspaper, but also through social media, through Twitter, through Facebook, or through YouTube. Then we have number two, slander. That is the defamation that is communicated through public speaking, open speaking, or free speech. Then the third concept that underlies media law is the question of the right to privacy. This is one of the rights that are always violated by different people, maybe those in the media fraternity, those who are practicing journalism, and just ordinary people as well. This has become indeed a serious problem. The fourth one is obscenity, which also considers the quality of the information, that the information given out there should not be seen to be perhaps harming somebody who may be considered vulnerable in the society. For instance, the minority, the children, those who are below 18, people with some kind of mental fragility, and they may be complacent with any type of information that is given out there in public. So the question of obscenity is equally very important. Then we have the question of intellectual property that includes the Copyright Act as well as Patent Act. We have different acts as trademark that deals with the intellectual property and that instigates areas of identity theft, areas that involve individuals in violating copyrights of other individuals. And this one may land one in the court of law. All in all, these are the supreme ones, and we need to admit that media practice has gone beyond the mainstream media in terms of the press, in terms of radio broadcast, in terms of television. And now, or today, we talk about the digital media platform in which a lot of information passes out there and beyond the national borders, beyond the domestic law and the jurisdiction of a country such as Kenya. The Republic of Kenya is a sovereign state with integrity and has got also its legal system that is meant to deal with media offenses, media practice, and the practice of journalism. This is why we are here to elaborate which are the laws regulating the area of media. Media law is corpus juris. It's a body of principles and rules enacted by the sovereign government and sanctioned by the authority, and it is meant to regulate or govern the freedom of expression and how the media and its practitioners participate and comply with the law. In accordance with the Constitution, which is the fundamental or the supreme law in Kenya, allow me to give you a list of the sources of law in Kenya. We begin with the Constitution, and the Constitution of Kenya has got so much to do with the freedom of expression, right to access information, media freedom, and limitations of such freedom under the context of propaganda for war or incitement for violence or engaging in hate speech and other illegal practices. The authority of the Constitution gives the media the rights, but also puts such limitations that regulate the sector. Number 2, apart from the Constitution, in the list of the sources of law in Kenya, is the Act of Parliament. You know, Parliament is devolved. We have national parliament and we have county parliaments known as county assemblies. The only body or arm of government that is mandated to enact or make law is Parliament. And the executive assents the law and enforces the law. The judiciary interprets the law and also enforces it by the decisions that the court makes. Here we admit that the Acts of Parliament in Kenya do not only address one Act of Parliament dealing with media law. There are several of them. There is what I would call fragmentation of statutes that deal with media sector. For instance, Kenya Information and Communication Act of 1998. We have Data Protection Act of 2019. We have Media Council Act of 2013. Then we have Access to Information, we have Defamation Act, we have Copyright Act, and we have Kenya Broadcasting Corporation Act. What are these acts about? These acts create institutions and government agencies that regulate the area of media. For instance, Communication Authority of Kenya that licenses media practice in the Republic of Kenya. Then we have Media Council that is mandated with regulation of the media. So media is regulated by a statutory body known as Media Council, and the Act creates also the Media Council Commission, whose work is to receive complaints from the media fraternity but also from the public, and deals with those complaints, assessing such complaints, adjudicating over such complaints, and making decision over such complaints. And in case of the need or need be, then such matters may also be taken to court. And looking at this Act of Parliament, which is the bulkiest part of our study, we need to admit the third source of law in the Republic of Kenya, the common law, which is also known to be the case law, the law of precedence. This is the law known as judgment law. That means the judges of the superior courts make decisions and their decisions become binding. In that case, it relies on the principle of stare decisis, stand by the decision, which means those such rulings or such orders or such decisions made by superior courts from time to time become binding, unless perhaps this is within quote the legislature overrules them. But this has not been overtly a problem in the Kenyan legal system as per now. And common law and the doctrine of equity are part and parcel of the sources of law in Kenya. Then we have the international treaties, multilateral treaties, bilateral treaties that Kenya ratifies from time to time as sources of law in the Republic of Kenya. The general rules of international law as well are part of the laws of Kenya as per the Constitution under Article 2, Sub-Article 5 and Sub-Article 6 will tell us the same as contemplated. Notwithstanding the role played by the African customary law, which is also a guiding principle for the Supreme Court, the Court of Appeal, and the High Court, and all subordinate courts in the Republic of Kenya on civil matters, but also only for those who are affected by such customary laws. All wrapped together will help us to pursue our studies and our knowledge about the media law, and it will help us to understand many other detailed problems and dynamics in the media law as per now. What has changed or what is changing? How should journalists today equip themselves and also protect the rights of the media, the freedom of expression and the freedom of media and the freedom of the press? How do we juggle out the role played by the government to regulate the media freedom or restrict it, and also to maybe check and balances that comes with stringent laws and policies that sometimes may see the media being threatened or being suppressed or oppressed by the authority. The battle is not far from the reality, but what is fundamental in this substantive presentation is that those who are interested in pursuing this course, you are welcome. I